police of the commission of a cognizable offense, and the police will lodge an FIR and start the process of investigation. Now, if the police does not register an FIR, what will he do next? He will go to the magistrate and under 156(3), he will seek the investigation of the agency. Right, Malaj? That's the second thing that he will do. Now, Malaj, if the investigating agency is not investigating the matter, months pass, years pass, no investigations take place, what is his remedy? Then he comes to the writ court and he files a petition under 226 and he says that, look, I did this. I went to the police station. I gave them information. They did nothing. They were sitting for months. I went to the magistrate. The magistrate directed them to investigate. They have not been investigating. They've been sitting for years. I have no remedy. I file a petition before you under 226 and please direct the investigation to take place, right? Or if you feel in the facts and circumstances of the case that the investigating agency is not purposely investigating the matter and because of certain other interests involved, some high public functionaries involved, then please send it to an independent investigating agency. Well, that's the first thing that he would do. This did not happen in this matter. Right? Well, yes. He goes in July, then he goes under 156(3). Magistrate says get sanction. Sanction is given by the governor, and then the Lokayukta gets into the picture. That's right, brother. So that's what happened in this case. So the normal circumstances, your lordships would not allow a petitioner to move the court for the purposes of sending a matter to one agency or another. That is one aspect. Now let's conceptually look at another situation. That in fact, brothers, an FIR is lodged, investigation is going on. Brothers, yes. And status reports are filed. And brothers, the particular person concerned who has lodged the complaint is not happy with the course of the investigation. Right? He's not happy in the way in which the magistrate is also dealing with it. So he goes to court under 226. And he says that, look, this investigation seems to be biased. Right? It seems to be colored. It doesn't seem to be going in the right direction. And therefore, you please direct this matter because I don't think the state agency, investigating agencies are interested in investigating this matter. They are moving in the wrong direction. So please direct this matter to be sent to an independent agency. Well, that's also not happened in this case.
It gives reasons for why it's
right. And then, in that situation, the powers of the investigating reports are filed in court. The status reports are filed in court. Both parties are aware of it, and both parties argue the matter. And then the court comes to a conclusion based on all the judgments that both sides have cited. Well, I will not repeat, both sides have cited in what circumstances your lordships will then refer the matter to our investigation. That's the second conceptual situation. Now the third, you take a case, where a particular investigation is being conducted with respect to a drug cartel, which has cross-border implications. Right, Malaj? The investigation is going on in the state. There is no taint in the investigation either. The petitioner will come to court and say it has extraterritorial ramifications. It may deal with a, drug trade, it may deal with sexual abuse, it may deal with chit funds, it may deal with any number of matters which have terrorism, it has then of course the NI will take over it. It has cross-border implications. And therefore the court will say that, look, the state police, or sometimes it happens that there are highly technical issues involved like SEC regulations, some special statutes. And the court says, look, the central agencies are much more conversant with these issues. Let the matter be decided. That's the third set of circumstances in which the matter can be transferred. There is a fourth set of circumstances. Now, and that fourth set is that if those who are being investigated are themselves the accused. For example, the police is indulging in sexual abuse and they become accused in the case, and the state itself is going to investigate police officers of that very state. Right? And then the court will say, no. These people themselves are the accused. The police agencies themselves are the accused. How can we allow that state to investigate the matter? Right? Then, the matter is transferred outside. These, if I understand the law correctly, these are the only 4 situations in which the matter can be transferred out. Now, with the greatest respect, the petition filed in this court doesn't fall within any of these situations. Doesn't fall within this court in any of the situations. So that's the first submission, that I wish to make before your lordships. The second submission that I wish to make before your lordships is even more important. In every case where the investigation is tainted, mala fide, not going on properly, both parties are aware of what the investigation has been, what has been the investigation carried on. And it's only after hearing both parties that the court decides that, no, I need to transfer this matter out. In this case, at least the state is not aware as to what is happening. The state is not aware as what has been the investigation. Nobody knows, neither the petitioner knows, nor anybody else knows, or those who are standing for the accused know, as to what investigation is going on. And in the absence of that knowledge, how will anybody decide that the matter will have to be transferred somewhere else? There is no instance in the history of the court where such a thing has happened.
So if the investigation is shoddy, then yes.
No. That investigation has to be known to the people concerned.
Yes. Known after getting to know. Yes.
That's right. Therefore, then they have to argue as to why it is not shoddy or why it is shoddy. And then your lordships will decide. That's the other way, that's one way of doing it. There is no other way. There is no other way in law for a matter to be transferred out in any fashion. But I'm coming to that. I'm just giving your lordships in what circumstances. We are in a different situation, different from all the cases that have been cited by both parties, according to me. Right? Because there is a report that is filed with you. Right? Parties don't know what that report is. Right?
Yes.
Now, what happens, and the PIL petitioner, because your lordship is a special court, the PIL petitioner, supposing the report, now the third conceptual argument, supporting whether the final report is filed or a closure report is filed. Right, And if a closure report is filed, what happens? What is the jurisdiction of the magistrate? He, then allows the PI, gives a copy of the closure report to the PIL petitioner. Right, your lordship knows, in Zakia Jafri's case, that's exactly what happened. The closure report was filed as far as the Gujarat matters were concerned. And then the magistrate gave the closure report to Zakia. She filed a protest petition. And then the matter went right up to the Supreme Court, and I argued that matter. So, then the third set of circumstances is a closure report stands filed. The magistrate gives the PIL petitioner the opportunity to file objections. So the entire matter is before the court and before the public. Then the prosecuting agency, says that, look, this closure report has been rightly filed or wrongly filed. Right? The accused will say it's wrong. The complainant will say it's wrongly filed. And the accused or the prosecution may say it's rightly filed. And then your lordships will decide. Right, Conceptually, these are the only circumstances in which a matter can be referred to another agency. Right, Now, none of these circumstances exist in this case. So the fundamental question which your lordships will have to decide, can you as a court have the jurisdiction to refer a matter to an agency outside the state without any of the parties knowing as to what the report is? In other words, does the court, it's not a jurisdictional issue, but it's an issue of fairness for us. Does the court on its own come to conclusions? Now, with the greatest respect, it's my humble submission that that's not possible at all. That's just not possible. It's never happened in the history of this court. Right, Now, these are the 3 conceptual arguments that I wish to make. Now the more important argument. The entire basis of the arguments of my learned colleague, Maninder Singh, is that the chief minister is involved. Right, Malaj? And therefore, the state cannot investigate, even Lokayukta cannot investigate. Now, Malaj, if that argument is right, Malaj, then the Lokayukta Act, to the extent that it allows the chief minister to be investigated, is unconstitutional. It has to be declared unconstitutional. Because as a matter of law, my learned friend cannot argue that because the chief minister is involved, therefore the Lokayukta cannot investigate. It's against the statute. The statute says that the chief minister will be investigated. Not only will be investigated, has been investigated in the past and has been convicted in the past. So
Yes.
there was no taint then. There the chief minister could have been investigated and convicted. But in this case, the chief minister cannot be investigated because he is the chief minister. Somewhat, Mullah, it's a very ingenious argument which cannot stand the test of law. What does the Lokayukta Act say, Mullah? Kindly have a look at the Lokayukta Act.
Okay.
Because this case, Mullah, throws up issues that have never arisen in the country before.
That's the problem.
I'm sorry?
That's the issue to be decided now.
No, correct. I'm saying that, Mullah.
Yes, yes.
There is no procedure known to law. No procedure, and I say, Mullah, with some amount of responsibility, known to law, by which your lordships on your own can refer this matter to the CBI without anything more, by just looking at the report.
Yes.
Or Mullah agreeing or disagreeing with the report. Whereas what does a magistrate do? He may disagree with the report.
No, that is his
Then
domain.
I'm sorry?
That is the magistrate's domain to disagree with the
No,
report.
but your lordships are in that position.
That way, yes.
I'm only saying that, Mullah. That's why I'm making that submission only because of that. Your lordships are in that position. Your lordships may say, I don't accept it. Therefore, reinvestigate the matter.
Yes, that is permissible.
Right?
Yes.
That's what the magistrate would do. That you reinvestigate the matter, or I accept the report. And if I accept the report, then the protest petition can be filed. But that will have to be done at the level of the magistrate. Because ultimately, this will go there, Mullah.
Yes.
Right, Mullah? So then he can file a protest petition if there is a closure. If there is no closure, Mullah, then he'll be prosecuted. There are only two possibilities. Or your lordships will say, I am not happy with this investigation. There are certain other matters that need to be investigated. Let the Lokayukta investigate those matters and reinvestigate the case. That's your lordship's jurisdiction. I'm just indicating because conceptually your lordships will have to decide. Forgetting about the judgment, these judgments are only mullahs to show that, look, CBI in certain circumstances is entitled to investigate. I'm not on that issue yet. Now, mullahs, kindly seek the Lokayukta Act. Statements of objects and reasons. Mullahs, write third sentence. The bill provides for the appointment of a Lokayukta. I'm sorry, much.
Yes, sir. I'm there.
And one or more Uplokayukts to investigate and report on allegations of grievances relating to the conduct of public servants. And the public servants who are covered by the Act include the Chief Minister. Right, Mullahs? Then, after that, Mullahs, sentence starting, Mullahs, and paragraph